Hi, this is Jen Rubin, editor-in-chief of The Contrarian. We are delighted to have back our Supreme Court whiz, Stephen Vladeck. Stephen, welcome.
Thanks, Jen. Great to be with you.
Well, these days, being a Supreme Court whiz means that you are constantly on the hot seat. Geez,
It is busier than usual. This is for sure, and that's never a good thing.
exactly. We were talking just before going on, like, which tragedy do we want to talk about? But let's start off on a good note. Lisa Cook. The Supreme Court decided not to enact a stay, and therefore she remains in her job. Talk to us about what the government was asking and not asking, and what you make from its decision.
Sure. So, Lisa Cook, of course, is on the Federal Reserve Board of Governors, has been targeted by President Trump, at least presumably because Trump does not think she's going to be sympathetic to what he wants to do to interest rates. So President Trump ginned up this charge that she had somehow committed mortgage fraud and invoked that as his basis for purporting to fire her. Thanks to some really good reporting from Reuters, it became pretty clear pretty quickly that the charge was, I believe the technical term is Bullocks. And the district court basically blocked President Trump from removing her. The DC Circuit, the Federal Appeals Court, left that decision intact, and the Trump administration went to the Supreme Court asking the court to let Trump remove her while this case goes forward. Jen, as you know, this is different from the slew of recent cases we've had with President Trump removing members of the National Labor Relations Board, the Merit Systems Protection Board, the Federal Trade Commission, the Consumer Product Safety Commission, because the Supreme Court had already suggested that it was not as willing to strike down the for-cause removal protections for Federal Reserve Board members, which is why Trump had to come up with some, putative basis for removing Cook for cause. The court on, I guess, Wednesday now, right, basically kicked the can down the road. It did not deny Trump's application, but it didn't grant it either. It deferred it pending an oral argument that will take place in January. So Cook stays on the board for now, but the court might, decide down the road that either Trump had cause to remove her or that whether there was cause or not is not a question for them. I mean, that's all still to play for. So it's different from these other cases because the Supreme Court thinks the Fed is different. Now it raises this other question, a question that we're seeing come up in so many different areas in Trump cases, which is if the president says he's doing something for a reason we all know is nonsense, to what extent can the court second guess that reasoning?
And we are going to go through a whole series of those. You're absolutely right, of course. Just to be clear, has the court granted cert on the underlying issue?
No. So this is, I really I feel guilty every day that like my job is nerdy Supreme Court procedure. The court is holding oral argument on the government's application. Basically, what should we do temporarily? And the most recent example we have of this, of course, is the birthright citizenship cases where the court held oral argument in May rather than decide them in April. And we know what happened in those cases. So, it used to be unheard of for the full court to have an oral argument on an application. This is now going to be, I think it's the fifth since 2021. But, presumably the court is only deciding what the interim rule should be for Lisa Cook. Although it's hard to imagine that they won't say at least something about the underlying merits here. Jen, one last point. In the Slaughter case, this is the Federal Trade Commissioner case that the court not only granted a stay in last Monday, I guess 11 days ago now, but in which it also granted cert before judgment, put that on the merits docket. The second question presented in that case actually might matter a lot for Lisa Cook, because the second question is, okay, suppose a federal officer has been wrongly removed. What remedies can the federal courts provide? Can they actually reinstate the officer, or is the officer limited to back pay for salary that he or she should have received? So Slaughter and Cook now actually become, to some degree, tied together. And the Slaughter case is going to be argued first. It's going to be argued in December.
And that may be one reason why Cook is going to be decided beyond that. Now, again, on the Supreme Court nerdy front, Humphrey's executor, which has been good law on whether you can remove these independent agency heads. The Supreme Court has yet to get to that on the merits. All of these are kind of shadow docket decisions hinting one way or the other. It's almost like we're in this weird world where the Supreme Court doesn't decide the most important underlying issue. It just deals with all the manifestations, and we're all kind of guessing what the underlying rule should be.
Yeah, I mean, I think that has been what we've been doing for most of the last 8 months, and it is profoundly unsatisfying, Jen, even without regard to the bottom lines. I mean, you could be content with these results or not, and still think that this is no way for the court to run a railroad. At least the Humphreys executor question will soon be answered. I mean, that's the first question in Slaughter. And so part of what the Supreme Court did last Monday in the Slaughter case was to hustle that question up for plenary review. I think just about everyone expects that the court will overrule Humphrey's executor, without regard to whether they ought to. I mean, I think one need not look far these days to see the value of having a modicum of independence in the executive branch. But, Jen, it raises this larger question about the pattern of the court's behavior, not just in these senior officer removal cases, but in general on emergency applications. I mean, I look at the horrifying stories coming out of that ICE raid from Chicago, and
Yes.
it's not that hard to sort of draw a straight line from the court's grant of a stay in the Los Angeles ICE raids case and Justice Kavanaugh's concurrence in that case to what ICE did in Chicago. And so, we're living at this unique moment where the Supreme Court can tell itself that all it's doing is these interim rulings and that it's saving the big questions for later. But you don't need to sort of be a lawyer to see the real world effects of these decisions and to see that the Supreme Court, whether it, accepts it or not, is massively affecting all of our lives, even if it doesn't think it's conclusively resolving these legal questions.
And I think that's so important that people understand this. First of all, in that decision out of California, it was again in a emergency stay. It was a concurrence, so goodness knows whether that's the law. But speaking to really underestimating, minimizing what these ICE stops are, we then had this horrific situation, and contrarians I know are kind of catching up on the news, some of them after having been out for a day or so, that there was this building in Chicago. They essentially emptied it out with children in zip ties, children naked, a gross overreach of action. And the Supreme Court might say, well, we didn't bless any of this, but they really did. And for them to live in this world of make-believe that what they say doesn't really have real world connotations is really a disservice to the justice system.
I mean, I think we're seeing in real time the very significant difference between a judicial decision that endorses particular behavior and a judicial decision that enables particular behavior, right? And the justices might swear on a stack that they haven't endorsed anything that the government's doing. But from our perspective, from the perspective of the folks in that apartment building in Chicago, the relevant question is, are you enabling the government's
Yes.
behavior? And, that's why the Cook case is interesting, because it is the first time since March that the Supreme Court, well, and I guess in the Alien Enemies case since April, that the Supreme Court has actually decided to not enable the Trump administration. Whether that's a harbinger of things to come or whether it's an outlier because the Federal Reserve is unique and the justices want to protect the markets, I think that's the big question.
And there are lots of questions that we will get to, I'm sure, on the Federal Reserve, including how really different is it? Are they making up an artificial line because they sort of like a central bank? How are they going to figure this out? But I think particularly with this administration, to pretend that you're not enabling it really takes willful disregard. But let's talk about that. The Supreme Court, of course, sort of kind of drew a little bit of a line in the Alien Alien Enemies Act, and lower courts have actually looked behind this declaration that we were under invasion and therefore we could use really extraordinary means to round up people and deport them. We now have a declaration from the President of the United States that we are at war with cartels. Last time I checked, number one, the cartels were not bombing American cities. Number two, Congress has the right to declare war. What is going on?
What is going on? So I think what's going on is two different but related things. One is the culmination of the broad, gradual transfer of war powers from Congress to the executive branch that really did not start with President Trump, and that has been going on for decades, where we've seen presidents of both parties claim ever more authority to use military force without statutory authorization and in contexts that really don't look like traditional self-defense, right? No one seriously argues that President Roosevelt had to wait for the bombs to fall on Pearl Harbor, right, to defend the United States on December 7th. But somewhere along the sort of the back pattern, right? Going backwards. You switch from defense to offense, and the Constitution says it has to be Congress. So the first thing to say is that move, that drift, has been going on for a while, and in some respects, this is just the latest step. But I think there are two pieces here that make this very Trumpian. The first is it's not just using force; it's saying I get to declare war. No, he doesn't. And no prior president has claimed a unilateral war declaration power. To the contrary, they've actually tried to avoid suggesting it's war. They've tried to suggest that these are limited strikes that were being used that don't trigger, right, the full panoply of the war powers. The second part of this, and I think this goes back to what we're talking about already, is the factual predicate. Congress authorized the use of military force after 9/11 against non-state actors, Al-Qaeda, based on evidence, based on facts that were presented to the legislature that, Al-Qaeda and the Taliban were responsible, right, for the September 11th attacks, right? The president saying, I'm declaring war against a group because I say something is true about them really is a dangerous escalation down an already slippery slope. And just one last thought on this. I mean, so Trump had sort of laid the groundwork for this by having Secretary Rubio declare a couple of these groups to be what federal law calls foreign terrorist organizations, or FTOs. But Jen, we've had FTO status since 1996, and no president had ever before claimed a connection between being an FTO and therefore automatically being subject to military force. Right? FTOs are there for financial sanctions, for criminal liability, for civil liability, not for kinetic military force. So, it is in one sense sort of a difference in degree, but it's also, I think, in important respects, a difference in kind from prior unilateral claims of war-making authority by presidents.
Now, two really, I think, important points you made. First of all, there is no war. And supposing that
Small detail.
yeah, small detail, that there is litigation, and it's a little harder to figure out who would have standing, unlike the Alien Enemies Act case, because there's not maybe a fisherman who is bombed out of the ocean. But would the court stop deferring entirely and say, you know what? We're not having, a war. We don't see it. Just like they said, the Venezuelan tanks are not rolling over the border, and therefore you can't use the Enemy Aliens Act. And then the second issue is, where the heck is Congress? This is the point where Congress is supposed to put up its hand and say, yes, excuse us, we're the body that declares war. And by the way, here's a war powers letter. The clock is now running.
Yep.
You either have to pull them back in X number of days or come
Yep.
back to us.
I mean, I know that where is Congress is a rhetorical question, but I do think it is worth asking it anyway, because historically, the reasons why presidents couldn't just bomb whoever they wanted for whatever reason they wanted was not because of the courts. It was because of the legislature. It was because of how that kind of move would have provoked not just criticism from Congress, but actually Congress pulling a bunch of levers to make it painful for the executive branch. We're seeing yet again, right, what happens when Congress just completely abandons any institutional role for itself. On the court's question, Jen, it's funny, every conversation about all of these Trump cases ends up being the same conversation, which is, we have courts that have historically been very deferential to factual claims by the executive, especially in the national security and war space. And we have increasingly not just preposterous, but dangerous factual claims being made by this administration. Um, when does that dam break? And, the tariffs case is going to be, I think, a small version of this when it's argued in the Supreme Court in November. The alien enemies case, which the government is deliberately trying to slow walk to the Supreme Court, it lost in the Fifth Circuit. It actually went out of its way to get the full Fifth Circuit to rehear that case for no other reason than delay, because everyone knows the Supreme Court will eventually take this case. Um, you know, this battle is going to be fought on so many different fronts. And I don't know at the end of the day what the Supreme Court's going to do. It seems to me that it will probably end up somewhere awkwardly in the middle, where the president still gets more deference than perhaps you or I think he ought to, but where the courts are not going to just blindly defer when you have a president who has no compunction and no political reason to be remotely careful about the facts. And the question is just if it's some intermediate position, how does that cash out in which cases? And I think that's part of why these cases getting to the Supreme Court on the merits this term are going to be so more broadly important beyond the specific issues they're deciding.
Absolutely. And, carried to the logical extreme, you could say Martians landed on the planet and therefore we're in a state of war. So at some point, if the court isn't going to look behind, it's completely taking
Right.
itself out of the ballpark.
Right. Or Trump says, we have been hit with a secret weapon that is causing massive radiological contamination, right? Trust me.
Yes.
Even though anyone with a Geiger counter can go out and say that's false, right? And I mean, it is easy to run the spectrum of sort of mildly preposterous to utterly preposterous factual claims. It's also easy to assume that courts will never go in for the utterly preposterous ones. But then the question is, how do they justify drawing a line, and what is the line?
Exactly. And in a related issue, you have written about the assumption of regularity, the presumption of regularity. I've written about it. Our friends at Just Security have done a masterful job. And this is the assumption that what the government is doing is done in good faith, that you can take its word for it because there are good actors who are acting in the country's interest. And I think what we are seeing over and over and over again, and certainly the lower courts have recognized this, is that ain't happening here. That's not what's going on here. And you see, I think, increasing frustration peak from the lower courts. And the question is whether the Supreme Court will continue that pattern or not.
And with the new Supreme Court term starting next Monday, it seems to me that that question may be the question of the term, which is, across. I mean, there are other big cases that don't involve Trump. We shouldn't dismiss those. But from the perspective of like the broader structure of our government right now, are there five votes to let Trump say that 2 + 2 = banana?
Yeah.
Um, or are there not? And, that's a lot is going to turn on the answer to that question.
Absolutely. And just today, we're recording this on Friday morning. There will be another one of these cases in Oregon because the Trump administration has deployed National Guard, and the people in Oregon are saying, for what? There's nothing going on here. And you're going to have a district court that's going to have to wrestle with that. But let's go to this term. You laid out one big theme that we're going to see. What else are we looking forward to or dreading in this upcoming Supreme Court term that we should kind of keep our eye on? Big picture.
Yeah, I mean, with the caveat that Jen, well, that it's always dangerous to predict in October what the Supreme Court term is going to look like by the end of it. I think it is generally true that the dominant story of this term is going to be Trump. Um,
Yeah.
we saw for last term that that became the dominant story as the court's docket became overloaded with all of these Trump-related emergency applications. I think in the coming term, it will be more of a mix of new emergency applications and these merits cases finally getting to the justices. We now know there will be at least three arguments in Trump cases: the tariffs case in November, the Slaughter case in December, the Cook case in January. If you told me that there will be more than twice that many by the time we're done, I would not bet against that. And so, what happens in the Trump merits cases is going to be big theme number one. If we can sort of like compress the non-Trump part of the docket, it's worth stressing. There are some really important ideologically charged cases there too, about transgender women participating in athletics, about conversion therapy and state efforts to sort of regulate speech surrounding conversion therapy. There's a massively important redistricting case out of Louisiana, in which the court has at least set itself up to take a massive bite out of the Voting Rights Act, yet another one. And in any other term, each of those cases would be very, very important and they'd be big deals, and they are. But it just seems like we're at a moment in our culture and our history where those are sort of inside the norm type cases, even if the court moves the law aggressively. Whereas the Trump cases seem like they are fundamental and historical, right, in ways that these other cases, for various reasons, don't. So I think it's going to be sort of both of those tracks pursuing at the same time. And frankly, Jen, does the court in the Trump cases actually buy itself some cover in those other cases, to be, ideologically split, to sort of to pursue the agenda that, I think is most commonly associated with the majority of the justices? That, how those two different courts talk to each other, I think is going to be fascinating to watch.
And horror of horrors that they should give one and take one away and act like, barkers at a carnival, selling one for to one side and the other to the other.
Yes, horror of horrors that the Supreme Court is one institution of government trying to be in conversation with other institutions of government. I realize this makes John Roberts uncomfortable, but
Yes. Two small things. One, I think the Second Amendment is going to be up there again.
yep, yep.
The court has taken another Second Amendment case.
Just this
And
morning.
I want to go back to Amy Coney Barrett.
Hmm.
You and I, over the last year or so, have had a conversation kind of fly-specking a little bit of distance that developed between her and, if you will, the other more MAGA justices. That difference seemed to disappear somewhat in these emergency stays. And we
Yeah.
don't know whether that means ultimately she's going to wind up in the pack, whether it is kind of a false warning. What's your best sense on where she is and kind of her continuing evolution as a justice?
Boy, I wish I knew. I think, I mean, your descriptive point, Jen, is absolutely right that we did not see nearly as much of the independent Barrett in the big rulings from the term that's about to end, including the emergency application rulings that we had seen as recently as a year ago. She writes the majority opinion in the birthright citizenship cases, a majority opinion that I think has lots of problems in it. Um, there's only, I think, two examples I can think of where she joined the Democratic appointees in dissenting on emergency applications. That's still two more than any other Republican appointee besides John Roberts, but that's only two. So, I think the answer probably is that she is still more independent than the others, but that may not show up as often as I might have expected or frankly hoped. But the other thing, Jen, is that what is so in one sort of breath vexing and also um, not nihilistic about the court's behavior on emergency applications is that they're not binding themselves in any meaningful way.
Yes.
And so, if it comes to pass that Barrett's actually horrified by what ICE is doing, if it comes to pass that actually she has real issues with the appropriation stuff that Trump is doing. It wouldn't surprise me to find her all of a sudden leading the charge, either in dissent or picking up John Roberts. In some of these cases are 5-4. And, frankly, I don't know that that will be necessarily consistent on her part, but maybe I'm okay with some inconsistency in this space. Again, I think that's going to be a really, really big theme of the term is where are Barrett and Roberts? Because, you and I have talked about this before. Brett Kavanaugh may be the sixth vote against the Trump administration. He will never be the fifth.
Yes.
And so, part of why Barrett is so important is because the only real candidates are her and the chief. And that's why so much of the focus is going to be on the two of them as we turn into the new term that starts on Monday.
And I think your perhaps unintended advice, or maybe it was intended advice for litigators coming to the court is pretend at least you have a clean slate and aim at the chief and at Barrett and hope you can draw some lines to keep us on this side of, as you point out, constitutional nihilism. Steve, it is always good to talk to you, even when it's somewhat horrifying to talk to you. But thank you once again, and I'm sure we'll be back talking about other unfortunate surprises from this
Thanks,
week.
Jen. One of these days, you and I will get together and we'll talk about, unicorns and rainbows.
Exactly, exactly. Thanks so much, Steve.
Thanks, Jen.